Thank you so much, Dean, and welcome to your first alumni weekend. So, your first of many, we trust. So, thank you, everyone, for coming today to be with us for this discussion of pro bono, the ethics of doing good. This is a time where we do need pro bono legal services, as Dean Jenkins pointed out, more than ever before. But pro bono defines our profession. It is really who we are as a profession. It's in many ways a unique obligation that we undertake. And at the Advocates for Human Rights, we work with volunteers from many professions. Pro bono in the legal profession is special. It is an ethical obligation. It is something that makes us, as lawyers, who we are. It has absolutely tremendous impact, whether it's on an individual case where somebody is able to remain in their home, to not be deported, to have access to justice, or in systems change in tremendous ways of pro bono leading the charge often in cutting-edge legal issues. At our office, we work with over 500 pro bono placed asylum cases every year, leveraging about $3 million in free legal services, leveraging our budget 10 times. We could never raise that kind of money. We could never do that work without the pro bono community that it supports legal service delivery. It is essential to justice. This morning, we are going to explore some of the enduring issues of ethics practice, in pro bono practice, rather, and some of the emerging issues that we're seeing, because things are changing. We're seeing new ways to organize, new ways to meet with clients, new ways that clients expect to meet with us and communicate with us. And it is really a delight to have this panel with us this morning. You've been introduced to everyone, and what our format will be is we're going to kick things off with a movie. So you can relax for 2 to 3 minutes. It's just a short film. And then we will be taking questions. I'll be posing questions to each of our panelists so that they can address issues first about these emerging issues around the practice at the immigration or the airport. Next, sort of our traditional issues that come up when dealing with clients, like any other clients. And then finally, what are some of the things that are really specific to pro bono practice that we as lawyers need to know and be aware of as we tackle cases that need representation, and we can step up to do that. So we'll start out here. I think I shall be able to make this work with a couple of clips from a project that you may have seen on the news, no matter where you live in the United States. And I'll let you take a guess right now what it is.
Attorneys are descending on airports all over the country, offering free legal help to travelers and family members whose loved ones might be impacted by the president's order.
Fox 9's Ted Haller's here now. Ted, a lot of people aren't sure exactly what this means or where to turn.
That's right. That's one reason why the volunteer attorneys were there today, Jeff. Just like there was at airports across the country, there was a group of volunteer lawyers at MSP. The ACLU also monitoring the situation, saying they're not aware of any detentions at MSP right now due to that executive order.
At MSP's international arrival entrance, there is nothing automatic about getting through the automatic doors.
An old family since last night texting each other, worrying about her, what will happen.
This Plymouth man worried whether his mom would get through these doors. She has dual citizenship with Iran, on President Trump's list of countries the U.S. won't accept immigrants from. She got through, And at her son's side were volunteer lawyers.
I was telling, I didn't know you guys existed. You are gifts from heaven.
What you're seeing is sort of the first wave response to the executive order that was issued by President Trump last week.
Lawyers from law firms and nonprofits spent Sunday checking arrivals, checking the law. Trump's executive order bans all refugees for 120 days, Syrian refugees indefinitely. It bans entry for citizens from 7 mostly Muslim countries for 90 days.
The broadness of it is just breathtakingly tragic.
On Saturday night, a federal judge ruled travelers already in the U.S. could not be sent back, but did not say the U.S. had to let them in. An MSP Customs and Border Protection officer would not tell lawyers whether anyone was detained there under the executive order.
Frankly, I think there's a complete lack of information at the local Customs and Border Protection level.
It seems discordant with who we are. That's part of why we're here as lawyers, not just to make sure people understand their due process rights, but to send the message that America is a place where people are welcomed, not where they're shunned.
The Minnesota ACLU tells me they've heard from 3 people overseas who are unsure right now if they'll be able to return to Minnesota. The Department of Homeland Security issued a statement just tonight saying they're working with airlines to keep people off planes who would be barred entry when they arrived in the U.S. They also clarified that lawful permanent residents would be allowed in unless there was, quote, significant derogatory information indicating a serious threat. Kelsey?
All right, thank you, Ted.
We have one more. It's a Saturday morning. We thought we'd give you a break.
People were just coming and saying, what can I do? It really made me very proud of the profession. What I did is I followed closely the order that was issued by by Judge Donnelly in the Brooklyn Federal Court.
And when President Trump enacts laws or executive orders that are unconstitutional and illegal, the courts are there to defend everyone's rights.
So I just went to Terminal 4, and there's sort of a hub there of attorneys who are volunteering to work on this issue, and attorneys were pouring in all day long. Lawyers from a lot of different backgrounds. The court ordered immigration officials not to deport anybody with valid visa, including a green card or other visa, who arrived in the country. We did not have information coming from the government about who was being detained, so our main task was to try to find out. And we were just canvassing people walking off of the plane. And we located the family of one of those people. He was Yemeni. He is a green card holder that resided in the Bronx. He had contacted them as he was getting on the flight in Doha, and the flight had landed about an hour and a half earlier, and they'd been unable to reach him at all. So we prepared a habeas corpus petition. So we didn't know whether he would be indefinitely detained. We didn't know whether he would be deported. As the attorney who was going to file it was reviewing it, the individual that it was prepared for was released from detention and came out and joined his family. And, their entire life is here. They have bank accounts here. They maybe have a business here. They have children here. This was not a carefully designed executive order. A lot of weighty attorneys who are very experienced in these matters have looked at this and said this was done very sloppily. The executive order leaves huge areas undefined in how it needs to be applied, and nobody really knows what to do.
So, how many of you have ever stood anywhere with a sign saying, free lawyer? Anyone? Regina. I think, Regina, you have. Could you tell us how this happened? What happened, and maybe give us a little background on the executive order, just so we know why you were out there, and then how this project unfolded.
Sure, thanks. So just to start, never send an email to a nonprofit saying you're happy to be a point person for an effort, because you really don't know how big it's actually going to get. I'm just kidding. I actually...
As the moderator, I would say, absolutely, step forward anytime.
So essentially what happened is that we'd heard there was a lot of anticipation about some of the immigration-related steps that the Trump administration might take after he took office, but no one was really quite sure what those steps would be. So one of the things that we kind of had an idea about was that something would happen around refugees. And prior to the executive order going into effect, the International Refugee Assistance Project, which is a project that assists refugees coming from other countries to the United States, they put out a call for attorney volunteers to sort of help manage and track and volunteer to go to airports where the IRAP is the acronym, where they would have individuals flying into the U.S. just to make sure that those individuals were allowed to be admitted into the U.S. And so I volunteered with IRAP and let them know that I'd be happy to be a point at Minneapolis-St. Paul Airport. And little did I know, a couple of days later, it was January 27th, the executive order, the travel ban essentially came down. And as you saw in the video, no one really knew what the reach of that order was, least of all Customs and Border Protection officials at the border, who are the individuals who are actually screening people to determine whether or not they will be let into the U.S. And as you saw, that was one of the main problems that we saw, was that there was just so much confusion surrounding who was impacted by the order, not only from people on the ground who might be impacted or airlines who were refusing to let permanent residents board in airports abroad, but also the actual government officials that were charged with implementing the order. So I received a message from IRAP, and I think started on a little email chain of about 30 people talking about, okay, what's the response at MSP? So I went down that first night, and it was pretty quiet, but there were probably a couple other attorneys that were there sort of hanging out. And as you saw at JFK Airport, so Minneapolis-St. Paul, in case you're wondering, doesn't have quite the international arrival volume that a place like JFK or Dulles has, but there still are definitely international arrivals flying into MSP. And on that first night, it was pretty quiet, but we sort of milled about talking to family members and friends to find out if they had anyone coming in who might be from one of the impacted countries, and mostly just sort of giving general information, making sure that people were getting through, and everyone did get through that we knew of, that we had spoken to family members about that first night. By the second day, I had about 600 emails in my inbox, which isn't normal for me, by the way. I don't know if it might be normal for you guys, but that's not normal for me. And honestly, by the end of the weekend, the response was so enormous, not only from attorneys from literally every practice area that you can imagine, corporate attorneys from Target or Best Buy to solos and everything in between, to interpreters, people with absolutely zero legal training who wanted to come and bring food because they'd seen the attorneys at JFK helping around the clock. I wanted to say yes to the food, but I couldn't in good conscience do that since we weren't actually sleeping up there. So the things sort of expanded from there, and literally by, I think, 3 days after this happened, we had a group of over 200 attorneys that were organized on a social media tool called Slack, and that has grown to over 300 attorneys at this point. But we also had to create essentially what amounted to a small organization. We had a structure of about 9 committee heads, everything from a federal filing habeas committee to a committee dealing with the MSP airport. And I couldn't have a sign actually because the MSP airport commission would not allow attorneys to have signs at MSP. We were able to have name tags, but just anything from figuring out how to talk to people and how to find out if there were people impacted, because as you saw, Customs and Border Protection was not providing any information, which actually was a change from past practice. I mean, immigration attorneys in general have typically had fairly open communication with local Customs and Border Protection as well as other branches of the agencies charged with enforcing immigration laws. That completely changed that weekend. So it sort of snowballed from there. We ended up with a pretty big committee and now over 300 attorneys, and we're still actually kind of going, but focusing on different areas now that there are a couple of stays of the order in place, and it's not actually being enforced at this point.
So, Diane, was this pro bono work?
Well, that's a good question. I would say I think some of it was. I think some of it might have been questionable, and so maybe that leads to what is pro bono work. In my mind, you have to have several things that characterize what you're doing in order to say that it is legal pro bono. One is you must be providing legal services. So these are services that you provide as a lawyer that by definition are not provided by other people who are not lawyers, unless they're engaged in the unauthorized practice of law, which some people do. But that is key. It must be the provision of legal services. You have to have a client. Now, the client may be an individual or it may be an organization like the advocates. I mean, if we're doing research for the advocates, then the advocates would be our client, but more typically it's the direct representation of an individual that you see as pro bono work. Thirdly, the work has to be undertaken at the outset without expectation of a fee, which clearly what was going on at the airport. No fees were contemplated by anybody. But this means that at the time that the work is undertaken, there is no agreement in place that the client or anybody else will be responsible for paying the lawyer. And then you get into, as a sort of secondary tier, who is eligible as a pro bono client. When you look at the rules, the model rules, they refer to persons of limited means. Other standards may say low-income persons. Other standards may say indigent persons. Sometimes it's people of modest means. So we're talking about people who, generally speaking, cannot afford a lawyer. And it's not just that they can't afford you or at your billable rates. They can't afford a lawyer, period. So you have to look at those kinds of things. And then there's obviously pro bono for organizational clients, but we're not going to talk about that now. So I had 20 lawyers who wanted to do this project, and they were very excited and were very, very supportive in our firm of pro bono work. But we do make a distinction between pro bono legal services and general service to the community, which does not involve the provision of legal services. And when I talked with the lawyers, none of whom were immigration specialists, what will you be doing? And the response, and perhaps this is what they understood they would be doing, was that they would wait outside the gate. If they saw a family or persons waiting that looked as if they might be waiting for someone from one of the 7 countries, they would approach, they would say, are you waiting for someone from one of the 7 countries? And if so, would you like legal help? And then they would hook them up with an immigration lawyer who was either on site or on call. Now, that immigration lawyer clearly was delivering legal services. And there was a habeas team. One of our lawyers served on the habeas team. She clearly would have been delivering legal services. But the lawyers who were making the one inquiry, are you waiting for someone from the right country? This was a little bit more troubling for me. And so then I asked them, well, are you collecting data? Are you interviewing people and collecting data for a larger advocacy effort, trying to squeeze them into our definition of pro bono? And they were uncertain about that. And obviously this was unfolding in a very quick timeline, and I give total credit and kudos to the organizers. But as I'm trying to think internally how we're going to handle this, this, it was posing some questions for us. So at the end of the day, I think we determined basically that the client was probably IRAP, and that our lawyers probably were gathering data, the ones who were not the immigration specialists or the habeas people. So we counted it as pro bono. But it was a very close call, and I think many people were motivated by being there, and being there is a wonderful thing, and solidarity with immigrants and solidarity with those who uphold the rule of law. But that is not pro bono service. And so to the extent that people were only doing that, I would question it.
Right. So why does that matter? And you can hold the mic. We're doing a 2-mic panel today, so just bear. Why does that matter? What is the impact of it matter being community service versus pro bono legal services? Because both are doing something for the public good, and clearly there's value to both, as you said. So why does that matter to us as lawyers to make that decision at all? And why do we need to know that?
Well, I think we have an ethical responsibility, and while it's aspirational to do 50 hours a year, it's very clear that it's a goal to do 50 hours of pro bono legal work. So in order to meet that standard, if you wanted to meet that standard, you would have to be choosing to do pro bono legal work. There are other states that allow CLE credit for pro bono work. So if you want to use your pro bono work to get CLE credit, you have to meet the standard of the pro bono work. And other states require lawyers to report their pro bono work. They may not require them to do it, but they do require them to report it. So you have to have some idea of what it is externally that you're required to do if you're using this for external purposes. But beyond that, I don't know. I mean, it really is a question of personal values, personal goals, aspirations to be of service to the community. I don't see a difference.
I would comment that there are duties that attach to providing legal services. If you're just doing community service, there may not be duties. There's attorney-client privilege information, there's communication, there's diligence, all of those things. So I think that if it's only defined as just community service and not pro bono work, it has a substantively different issue.
And I would actually agree with that. And just to sort of put this back in context of what was happening at the airport, I mean, certainly for individuals, even non-immigration attorneys there at the airport who are gathering information about potentially impacted individuals, I mean, that's certainly a situation where we would want confidentiality to attach, and we would want those obligations to be in place, and would want to be able to get informed consent and do all of these other things that are part of providing services. But just to speak to the broader piece of things in this is that I will say that one thing that came out of this whole situation for lawyers is I think that it gave people who are non-lawyers, just simply the broader public, an idea of what being a lawyer really is about. That all of these people from all these different practice areas came out and didn't care that they were spending 24, 48 hours at the airport and weren't charging. People were very impacted by that. And we're standing around in international arrivals and people would constantly come up to us and thank us for being there. And there were many lawyers who just wanted to go to the airport to be essentially emotional support for people as well. So I think this sort of speaks to one piece of the pro bono rule, and I think it's Rule 6.1. I'm not from Minnesota, but I'm going to cite it anyway. That it goes to the idea of sort of improving the legal system, the standing of the profession, et cetera. This is definitely something that came out of this entire event. So.
Right. So what are those rules that we have to follow? You said Rule 6.1, you're not from Minnesota, but yes, we do have a rule book, right? We're one of the professions that actually writes them down because we're lawyers and has them really have meaning and matter in our day-to-day work. we talk often in pro bono work about treating our client like any other client. But what does that mean when it comes to probably all our practice, but to our pro bono practice in particular? Brent?
Thanks. I'm going to digress for one moment.
Sure.
You may be familiar with the Legal Services Corporation at the national level, who distributes money to various legal aid services and organizations around the country. And we're talking about pro bono, but we're really talking about providing services to people who need it, who can't afford it. And the legal aid groups around the country do that, of course. Well, you may or may not be aware that the proposed budget, federal budget, zeroes out the funding for Legal Services Corporation. And depending on the legal aid group that we're talking about, I mean, the metro legal aid groups, they don't depend on net funding as much, but outstate legal aid does. And every year, it's perennial, the ABA goes to Washington and advocates to ensure sustained funding for the Legal Services Corporation. And what that involves is contacting legislators and talking about how important this issue is. So I would, if this is an issue that's important to you, and you agree with the kinds of things that legal aids do around the country in terms of the services they provide, I would encourage you to contact legislators, congressmen, senators, about this particular budget and how important it is that people have access to justice. So I think that's an important point. Secondly, as you may or may not be aware, the Minnesota State Bar Association has a North Star program, and anyone who provides 50 hours of pro bono work within a year qualifies and can be certified as a North Star lawyer. And if you are retired and you have your license is inactive, the Supreme Court of Minnesota about 5 years ago changed the rules, and allows retired lawyers to provide pro bono services, and all you need to do is get 5 hours of CLE so that you're up to speed, as opposed to the normal 30 hours or whatever's required. So if you are a retired lawyer, and I envy you, but if you are a retired lawyer and wish to provide pro bono services, you shouldn't be concerned that because your license is not active, you cannot do that. You should be looking at that program.
Thank you.
Sure. Now, going into I feel like CNN, where the person answers the question they want to answer.
And you answered the question I wanted to ask. So perfect.
No problem. With regard to the duties, I mean, a pro bono client is a client, right? We are responsible to fulfill all the ethical obligations that the rules of professional conduct require of us for all clients. Now, pro bono clients may offer other interesting issues or perhaps challenges that we should be aware of, but you have a duty of diligence. You have a duty to communicate with the client, and that can be challenging depending on who the client is. You have to know who your client is. And why is that important? Because your duties are to that person, not to their family members, et cetera. You need to be very clear as to who the client is in terms of communication. I am not good at scope, but you want to identify what the scope of the representation will be and limit it. I have a pro bono client that I have worked with for 15 years. Right? This started out as immigration, went to family, did Social Security, unemployment. I mean, I have covered the range of subject matters, and I've learned an awful lot, but I never really narrowed the focus and made it clear as to what that would be about. Sometimes, of course, with all clients, you need to know if there's a conflict of interest. Now, with legal services, or if you're providing services through an organization, your duty of ensuring that there are no conflicts is limited. You don't have the same duty that you would with a normal client, and we can talk about that later, but I think that's important. Does the client understand what you're talking about when you speak with them? Do they have a diminished capacity? You need to think about the unauthorized practice of law. I mean, if you're providing advice on federal law, then you may not have that same issue. But if you are not admitted in the jurisdiction where you're providing information on state law, you need to be concerned about the unauthorized practice. Now, there are rules with the Supreme Court, at least in Minnesota and typically in other states, where let's say you're in-house corporate and you want to provide pro bono services, there are ways that that can be done, but you should be aware of those. But generally, you have the same duties that we have to all of our clients: confidentiality, diligence, communication, et cetera.
Great. Does anybody want to jump in on that? That's awesome.
I very much agree with everything that you've said. And I do think that it is often the context in which we see pro bono clients that makes them feel or presents different challenges. The rise of the brief advice and service clinic, where you might be in a court-attached clinic or one that's run by a nonprofit legal services in the community, where clients come in often on a walk-in basis, so you're not sure what the legal issue will be. Sometimes it's a specialized clinic like an immigration clinic, so you at least have some notion of the general area of practice. But people are roughly scheduled for 15, 20 minutes if they're lucky, maybe half an hour if they really are lucky. And they come to you for advice. You may be the only lawyer that they see in terms of resolving whatever the problem is. And it is very clear under Rule 6.1 that we were discussing, that if you are serving at such a clinic, you aren't held to the same conflict search standards, but you are establishing an attorney-client relationship. And so it may only last for 15 or 20 minutes, but nevertheless, you have a client, and in that 15 or 20 minutes, you are providing legal services, and you have all of the characteristics that attach to that attorney-client relationship compressed into 15 or 20 minutes. Often most people at those clinics are low-income clients who may or may not even be familiar with the law. It often takes that amount of time to get the story out in a logical way in which you can understand what the question is, much less provide advice. And this is a very challenging area of practice. I know that I probably differ substantially with many of my colleagues in my profession who say, oh, community clinics are great, starter pro bono opportunities for young lawyers. I actually don't think that's true. I think that it's very challenging, particularly in a clinic of general jurisdiction, to come in and actually competently advise somebody in 15 to 20 minutes. So I usually suggest pairing with a senior experienced lawyer for a while to sort of understand what's going on. And then other issues relate to language barriers. Increasingly, there are many people who have no familiarity with Western-style justice or the justice system, and people living in poverty present some special challenges relating to ability to communicate with you, ability to communicate with them if they have housing instability or their phones work intermittently. So those are the kinds of challenges that you may not see in your ordinary practice, but very much attached to pro bono practice.
And just sort of building on that, when we're talking about the airport response and attorneys speaking to family members who are outside the international arrivals area, there were definitely questions about how you can help someone who is on the other side of that door who you haven't spoken to, whether or not it's even possible to obtain informed consent for someone who, again, you haven't spoken to, who would be the potential client. The way that we sort of answered some of those questions was that, typically speaking, individuals who were being detained and questioned by Customs and Border Protection, we were not allowed back into the area to speak with the person directly. However, the individuals were typically allowed to make phone calls to their family members, and so we were actually able to talk to people in that way, often on a family member's phone or essentially not through a third party, but directly to the individual, just calling in. So it was definitely an interesting challenge to try to make sure that the individual understood this is what the scope of what we can try to do is, and are you okay with having us do that on your behalf? We did have a couple of people that we ended up almost filing two people we almost filed a habeas petition for, and one who we did file a habeas petition for, actually in conjunction with Frederickson Byron and Apollo Law. And I know Faegre was also on a couple of other close call cases, which we actually got through. But in one in particular, it was an Iraqi man who had a green card, and it was questionable whether or not he was going to actually get through. He was being detained for multiple hours, and we got to the point where we had the habeas petition prepared, and he was let through. But we were able to get consent by speaking to him directly when he called his family member who was waiting outside.
I was going to make one comment. I think attorneys, like to project confidence. I think there's a fear factor involved in some pro bono where people are thinking, because they know they have a duty of competence, as we were discussing, and they think, I don't know anything about this subject matter. I am not going to volunteer my time because I can't provide competent representation. You can get great comfort from knowing a few things. Number one, most of these programs have a training and put you through training, and they want you to have as much information as possible before you go out there. Secondly, on these quick advice type clinics, and I've done that as well, you'd be surprised how much you know. And you don't even realize what you have forgotten. And you have to be competent enough to issue spot. You don't need to necessarily have the answer at your fingertips. You need to discuss with them what the problem is, understand what subject we're discussing, and if you don't know the answer, and how many of us have been asked a question we don't know the answer to and say to the client, I'll get back to you on that. That's okay, right? So you don't, and the standard that lawyers are held to for for this kind of work is that of a general practitioner. Do you understand precedent? Can you write? Can you research? So I would not be intimidated about taking these cases on because, number one, they'll train you typically. Number two, sometimes they'll have someone sit next to you, even if it's not a lawyer who's familiar with the kinds of issues that are addressed in these clinics and can advise you and do research for you while you're sitting there. And you can always get back to the client with information.
And actually, that's a perfect, I think, example of what. With the airport response, we had tons of people with no immigration experience who weren't really sure what they needed to be doing. So we came up with a standard operating procedure to really lay down the steps of exactly how people were going to function when they got to the airport. So step one, identify people standing around. Step two, talk to them. Step three, find out if they're from one of the 7 countries. If they're not, that's the end of things. We can't help because we're only there for this limited purpose. So I think that when you have a situation where you are working with an organization, you should expect those things, frankly, and you should expect that they are narrowing the scope of the pro bono representation, honestly, for you. You should have an idea of what you're doing when you're going in. And even with the airport response, we created CLEs sort of in a snap and had people, we had, over 100, I think 120 or 130 people attend just the first CLE to sort of explain what the process was and what we were actually doing down there. And then pairing people with an immigration attorney who was on call, as well as a federal habeas filer who was also on call. So anyone going down to the airport who was, an IP attorney, they were not being expected to file a habeas. It was very, very delineated what the role was. Maybe not at first, but after a few days of working on things, we, I think, sort of figured it out.
One of the things that I discuss with young lawyers at orientation is thinking about their pro bono professional life and career arc at the same time that they're thinking about their billable practice. And so many law students who come into the profession have already done pro bono work as part of their legal education, so they're familiar with certainly the concept, they're familiar with clinics, they're familiar with working with low-income clients. And so when I talk to young lawyers, I say they should try a variety of experiences in order to sort of see if there's a niche or a practice area that speaks to them, bearing in mind that training is essential. And this Minneapolis or Minnesota in general is a hotbed of pro bono activity. Nationally, we're known for our high rate of pro bono practice by lawyers. And so you have a lot of choices and options in this state about the kinds of pro bono work you want to do. So I do encourage young lawyers to try it out. We work with one provider not in this state who likes to place cases, and these are asylum cases with untrained volunteers on the theory that they'll get the training later. And I have put a stop to that practice because I find that kind of appalling, in part because you don't even know what kind of case to take if you haven't been trained. And there are some processes, I think, by which you can have a starter case and then take a more difficult case and then take a more difficult case and build expertise. And that's what we talk to our young lawyers about. Become an expert in something so you can supervise younger lawyers and you can be someone who has genuine leadership and expertise in pro bono practice. So that's the importance of training and supervision. We have all of our cases supervised by a lawyer, a partner. We certainly hope that they're actively engaged in the supervision, but it is no different from our billable cases. And I think that's an important communication to younger lawyers that the way we treat pro bono clients in the firm with respect to all of our processes and procedures and accounting and reporting is no different than what you are doing for your billable clients.
Diane, and you mentioned sometimes representing organizational clients, pro bono. And could you talk a little bit, any of you, about that? Because we do frame pro bono in terms of the individual case, but we also do have the opportunity to provide pro bono services to organizations. What's different? How do you go about structuring that? What kind of options do people have when it comes to that?
Well,
raised it, so
I raised it. Okay, I own it. We get a lot of requests for pro bono assistance from nonprofit organizations. And as I sort of look at them, we have developed what we call a means, mission, and matter test. We balance three things. One is the mission of the organization. And so if it is a private mission, if you could be a tax-exempt organization that represents a professional interest, we would not usually consider that to be a pro bono client unless it is related to the matter, if the matter is some public interest matter rather than that of the narrow professional interest. But we look at the mission, so we tend to end up with human rights organizations, civil rights organizations, arts, education, those kinds of things, those kinds of organizations. Then we look at the means of the organization, because many organizations already pay lawyers for their legal services. And so I look at the 990 returns, and it is almost always a kiss of death if there's a line item for lawyers, because if they're paying other lawyers, I don't think that I reasonably can ask a lawyer at my firm to do the work for free. And then I look at the matter, because it may be that even though the means might be sort of too much, that the matter is something that is a public interest matter or something we'd really be interested in doing. And I always give as an example something like a prominent theater, which already has paid counsel, might decide to create a school for underprivileged children in an underserved community to train them in theater and drama. And they need someone to look at contracts or do the real estate deals or something. We might be interested in that. But I do think it's a moving target. And on that side of it, we do represent some organizations, but it is certainly not the bulk of our practice. And then we also do provide pro bono legal service to legal services organizations, because they also have needs. And that's kind of a different specialized matter.
I would comment that even if you're working through an organization and you are providing services to an individual because they have need of legal services, that's your client. Even if you're working through the organization. And I think that the Supreme Court would think that. I think that the ethics boards would think that. And so you owe your duty You owe your duties of your fiduciary duties and your duty of loyalty to that individual. And that, by the way, engagement letters, I live and die by engagement letters. Part of being general counsel of a law firm is my job is to scare people. And I relish that. But the engagement letter is really important for both the client and for you, because it says, I represent you. I don't represent your sister, your brother, your mother, your father. I represent you, and I represent you on this particular matter. And this is what our understanding is going to be. Here's what your responsibilities are, and here's what my responsibilities are, and you need to be very clear. I think, clarity on the front end is in everyone's best interest, and it will protect you down the road. So, again, I just wanted to reiterate who the client is, right?
Very definitely.
So going to that, when you're working with a client who, perhaps this is their first encounter with the justice system in any way, perhaps it's their first encounter with the American justice system, perhaps they are a child. How do you get really clear understanding and informed consent? We know we're supposed to do it. What are the tactics you use to accomplish that?
So, first of all, I have to say that, after spending almost 10 years in private practice in immigration law in Arizona, I learned that I really like to wear jeans and Chuck Taylors. And to be honest with you, I know that sounds silly, but when you're working with a lot of times teenagers or young people or people who have absolutely zero trust of the government for one reason or another, not because it's the American government, but because they've had a bad experience with the government of the country and from which they're from, it can really help to sort of present yourself a little bit more casually. And I've found that really does help in building rapport with people. And the other thing that goes into that, though, is being very clear about responsibilities and expectations from the beginning. I couldn't agree more about the engagement letter piece of things. I've found that when you're very upfront with someone and very clear with them about the risks of going forward with any particular course of action or the different options that they have, and you actually sit down and take the time to explain that to them, it builds rapport and it builds trust with that individual, which definitely does help with the piece of obtaining informed consent. But the other piece of that is that when you're working with someone through an interpreter, or you're working with someone who's a child or who you think might have some type of diminished capacity, you definitely have to watch and pay particular attention to whether what you're communicating to that individual is being understood, which can be difficult when you're working with an interpreter in particular. But B, whether any protective measures might need to be taken to ensure that the person that you're speaking with does actually have an understanding, or their interests essentially are protected in the representation. So, for example, when working with a child, the ethical rules say that you have to treat any client as a client, just like we've said, regardless of whether they have diminished capacity, regardless of whether they're a 4-year-old child. It doesn't matter, they're your client. But there are certain steps that you can take to ensure that they can actually participate in their own representation and that their interests and their wishes are heard. And one of those things that I've done in the past is, is there a parent there? Is there someone who can help to ensure that, okay, their interests are protected? But at the same time, you have to be careful about confidentiality issues, because you'll also have occasionally someone who might be 25 and their parent wants to sit in on the consultation. No, I typically will start with only the individual who is the prospective client, because I don't know what they're going to, I want them to feel comfortable enough that they can reveal to me whatever information is necessary for me to effectively represent them. And if that's something embarrassing or something that the parent doesn't know about, I don't want the parent sitting in there initially. So there are all these things that you have to think about when you're representing someone that may be a little bit more complicated client than the typical quote unquote client.
One possible approach is what they call client-centered interviews, where you ask the child, what do you think the consequences of this particular course of action would be? And let them explain in their own words what they think we're talking about, so that you get a feeling for whether the message is getting through. As opposed to talking to them, let them explain it back to you. If you find that there is a significant issue with this particular client, this particular child, there's always guardian ad litems that can be appointed who are to act in the client's best interest, obviously the child's best interest. And the other thing to note that children as young as 5 and 6 have been recognized by the courts to have some understanding and should have some value. Their input should be valued. Children can sign engagement letters. Now, that doesn't mean they're not, voidable when they're 18 or whatever the case may be, but a child can sign an engagement letter, and obviously you'd want to kind of go over that carefully with them, and again, use client-centered type of discussions with them so that they understand what it's about.
With respect to children, I think a stream of cases that present some very challenging issues have been the kids from Central America who have come up, and for the most part, they're all in removal proceedings by the time they make their way to communities around the country. And they also, at least until recently, were the top enforcement priorities in terms of removal. And so they were all on rocket dockets. And so the kind of timing that you might normally have to develop rapport and get the story out and simply was not available for these kids. And all of them obviously had language issues too. So you needed to work through a translator, so that presented that. And for some of them, they were rejoining family members with whom they may not have lived for multiple years, and they were teenagers. And you can imagine that presented some challenges in their living arrangements. And I know we had at least one parent, because we try to work with the child and with the family as well, where the sponsoring parent actually was adverse to the child client. And that was very difficult for us, because it was difficult for the child, but it was difficult for the child's lawyers too. So I think you have to just understand where you are and be alert to that, because normally one would think that parents pretty much support safety for their children and support stability for their children and want them to get legal help, but that is not often the case, or that's not always the case. And then when you also, if you're working with children from the Children's Law Center, which runs a fabulous pro bono program, these are children who for the most part are removed from their parents, and so they don't have that circle of family support around them, and so the lawyer can be really a very important part of that child's life and that child's future as they work their way through juvenile protection proceedings.
Do you, and this, feel free if you don't feel comfortable answering this, but we're not mandatory reporters as attorneys, because we're mandatory confidants. But many of the people who interact with child clients are mandatory reporters. How does that play into your decisions on who to involve as an interpreter or to involve in the case matters? And how do you work in a way that preserves confidentiality but also ensures the safety of the child?
So this is actually a great question, because one of the things I think is sort of Brent's situation that he talked about earlier, the CLE client or the pro bono client you've had for 15 years. It illustrates a really great point about, in particular, immigration cases. Typically, when you take a case, it's yes, you have the immigration legal matter, but there are also all of these other ancillary matters that come with it. And when you're talking about a child client, for example, there may be abuse allegations or other things that come up vis-a-vis the parent or another adult caregiver in the course of the representation. And so when you have individuals like social workers or other mandatory reporters, psychologists, that maybe you need to do a psychological evaluation, when those things come into play and you discover that there is an issue. So sometimes this comes up in the context of an actual conflict of interest after it's discovered, if you weren't aware of it before, or a potential conflict of interest. I think you follow the same rules that you would with any other potential or actual conflict of interest. And if it's to a degree, the conflict is to a degree that you cannot represent your client effectively, then I think you have to look at the proper course of action to take at that point. But immigration is certainly an area that's sort of ripe for these kinds of challenges. I'm sure other areas are as well, but we're dealing a lot of times with people that, for example, spouses that are trying to bring one over from another country. I mean, there are a lot of situations where you have dual representation or a close family member individual that's involved that is central to the individual's immigration case. So it's definitely something to think about.
So another area that I have really, that poses a particular challenge, I think, to lawyers is working with people who don't have literacy or have very low literacy levels, whether that's a different language or whether it's just someone who has no literacy skills. And I've been learning more. I think there have been some great CLEs and discussions about the culture of folks who don't operate within a literate culture and ways that people communicate. How do you handle that? We depend on giving someone a nice piece of paper with a list of things that says, these are my responsibilities, these are your responsibilities. You've read it, great, we're all clear, right? Because we're on the same page. But if somebody never writes things down on a page, that doesn't even apply. How do you go about handling those issues, getting informed consent and getting it in writing when you're not even sure your client is reading and understanding?
Okay, twist my arm. So this actually, a lot of times you won't know that someone isn't literate from the outset because it's not something typically that people advertise. And so you really have to pay close attention. And if you do suspect that someone is not able to read what you're giving them, the way that I would handle this in private practice is that I always used engagement letters or contracts that were in simple language, because if someone's first language isn't English, I'm not going to use legalese. Well, regardless of who they are, I'm not going to use legalese. I think it's critically important that people actually have an understanding of what representation you're engaging in. But going through that contract or that engagement letter with them, reading it aloud to them and having a portion of the letter or agreement that says, I have been read this agreement, sort of essentially acknowledging that the information has been read aloud to them in a language that they understand and that they consent to the course of action that's being outlined in the letter. That's one thing. And then the second thing is that when dealing with document and information collection, it can be a challenge as well, because a lot of us rely on questionnaires and document lists and things like that, it's like, oh, we'll just email it to the client, but it becomes very difficult. So then you have, in the past, what I've done is have my paralegals work with the individual, either over the phone or in person, to go through everything in speaking of everything and reviewing it orally with the individual to gain the information that's required.
Any other tips? So I think I might start with Brent on this one, because you've already admitted to perhaps some challenges with this, but boundaries. Right? Our 15-year client, for whom you are really general counsel, not just to your firm, but to that client, how do you establish boundaries? And what challenges have you found as you started out? How are you approaching? Is that different today after working with that client for 15 years? If you were starting out 15 years ago, what have you learned around boundaries? What should we be thinking of as we take those?
Learn how to say no. Honestly, I'm not a great person for this, but I think the engagement letter helps me now, because I make it very clear in that engagement letter that I am doing just this thing. And then I feel more comfortable saying that's outside the scope of our representation. So, the clarity in the engagement letter is helpful to them, but it's really helpful to me to set boundaries.
I completely agree with that. I think the other piece is that have a good list of attorney referrals in other practice areas that you're not comfortable in. So I know as an immigration attorney, I need to have a family attorney that I trust and know does good work, et cetera, et cetera. And so typically what I'll tell people if they have matters that arise outside of the scope of my own representation is that, look, I don't have expertise in that area. I would feel much more comfortable if you would speak to my colleague X who does have expertise in that area, and then they can advise you as to the steps that you need to take.
And we have an engagement letter in every pro bono case that we do, and I approve every pro bono case that we do. And ultimately, I'm sometimes called upon to say, could you just say no? And sometimes I just say no at the behest of a lawyer. But we also tweak our engagement letters and often stage representation. And in particular, when we have federal appointments and we represent people who are incarcerated who have already multiple grievances going on and may, in fact, have multiple pending cases. And on those letters, we are very carefully crafting that we are in for the one case and not anything else that you're involved in, not anything else that might come up in the course of the representation. But ultimately, you do have to just say no, even though it's painful.
So what about the non-legal matters? When I first started placing asylum cases with volunteers, I had a volunteer call me. It was the middle of winter, and his client had come in with no coat. And so his response, and he was very upset, and he said, so we went down to Dayton's. That shows how old I am, if anybody knows. He went down to Dayton's and bought him a coat, which is a great human response. We should do that every time we see someone without a coat, right? But how do you tackle that, and what tools do you give your lawyers on how to engage in a world that may be very different from the one they're used to? Either any of you. Then the students as well.
Well, I mean, in terms of when they want to help somebody, but it's not probably legal needs. I think it's having good referrals in the community for whatever it is: food shelves, housing assistance, emergency energy assistance, those kinds of things, and having a good network of those, or at least have some referral that you can make, even if it's just, is it 311?
Right.
Yeah, I mean, because people do have needs, but we also are not necessarily the best resources to meet those needs. So.
And I think, maybe I'm sort of in Brent's camp a little on this one, that I'm not probably the best person to ask about this, because I would have done probably the exact same thing. I think that there's sort of a distinction to be made between, if someone doesn't have a coat, buy a coat. You don't have to, but if you feel like you should, then do it. I mean, I've had clients released in the middle of the night with nowhere to go. I get them a hotel room for a couple of nights, at least, until I can get them a referral to a women's shelter or somewhere else. So I don't think it's a problem to sort of be a stopgap in a sense, as long as whatever your role is clearly defined, and as long as there's no continued expectation of support or something like that. I can't say enough that I think it's critical to be clear about what you're doing and the scope of what you're doing, whether it's legal services or non-legal services.
So you mentioned something about the airport project that maybe not everybody has been on. Slack. Can I get a show of hands of everyone who knows what Slack is? All right. Don't feel bad. Look around. Most of us don't. What opportunities, what ethical dilemmas are being posed by the proliferation of new social media platforms? And please do explain what Slack is to the best of your knowledge, Regina.
Slack is awesome. I actually had never even heard of it until the airport stuff that happened. Slack is essentially a business productivity tool that was created for project management. So you have these huge companies, Fortune 500 companies, that actually use Slack in order to organize their different teams, and it's just a fantastic organizational tool. It became very clear very early on that an email string wasn't going to cut it because there was just way too much happening in far too many places and with far too many actors. So Slack actually helped us to group things into areas, and where people had specific interests, for example, on legal research or on habeas, they could join that Slack group or channel to keep up on what was happening with other attorneys working on that particular issue. So now that does raise a lot of different issues. One thing about Slack is, we treated Slack as if nothing that we were writing was confidential. You have to, because it's extremely difficult to police who is signing up for the tool, and it's essentially just a communication tool, and we used it more for logistical things than anything else. But you can't assume that anything you're putting on that medium is going to be kept confidential, and therefore there was no identifying client information that could be shared. At one point, someone did post a copy of an individual's visa, which we immediately deleted and re-informed everyone, do not post confidential client information on this channel because it's not confidential. So Slack in particular, it's fantastic for organizing. It's not good for sharing confidential information or information that you would share, for example, in a firm environment, because we're not a firm. We're not even IRAP. We're a group of people that are volunteering to provide legal services to individuals on the ground. So you really have to know what the tool is, what the limitations of the tool are, and again, how you plan to use it and make that clear from the outset so that you're not in a situation where you do have a problem of, confidential information being released or something of that nature.
Nothing to add on Slack? Okay. Yeah. But there are other things that are emerging, like providing free legal services by phone or by Skype. What do you see as the future on that? For especially, as you mentioned, the threat to free legal services for the poor in the United States right now. Even today, with the Legal Services Corporation fully funded to the limited extent it is, people don't have access to lawyers when they need them. And in a state like Minnesota, where many people live far distances from a lawyer or from the legal aid or office, we're constantly trying to communicate with clients via distance. What are some of the things that you've seen that are promising, and are there any ethical issues that we should be aware of as we're kind of jumping into those new kinds of opportunities?
From the ethics perspective, again, it depends on where the client is and are you advising them on law in the state where they're located, and if you're admitted in that state. That's the first thing that would concern me. I would also, it's in terms of it's difficult electronically to understand if the client understands what we're talking about. Communication could be an issue. If you're face-to-face, you can look a person in the eye and get a much better feeling for whether or not the message is received. So I think the strategies have to be, the almost like the client-centered discussion. Let them talk back, tell you if they understand everything that we're talking about to ensure that everyone's on the same page, I think, and confidentiality, of course, depending on how you're communicating. When you were talking about social media, I'm thinking, I hope no one's posting a picture of the client meeting with the attorney, right? So confidentiality would also be an issue online.
We have offices in Indiana, and they have an online legal services system where people can log on and they can ask 3 questions and only 3 questions. And sometimes they are 3 questions with 20 parts each. And so somebody has to sort of decide we're only going to answer, this question. And that's where one of our family law experts was very helpful in, because a lot of the questions were coming in about family law. And he was saying, no, we're going to answer this question. And these are the 3 questions we're going to answer of the 60 posed. But I worry about that because I think, you're not in a position to see documents that might be helpful. You have no idea what is going to happen with the information you've provided online and how that will be absorbed and taken in and used for what might be, and most probably is a pro se litigant. I think there are concerns about that. On the other hand, for many, many, many clients, there is no access to counsel other than some system like that.
The one other issue I'd mention is you don't know who's in the room, and attorney-client privilege could be of concern. So you want to make sure you know who's listening.
Yeah, I think we are at a point now where we have more options to talk to people. We have more options to open up legal services to people who aren't geographically next door to us, through different languages, using interpreters, all of these different opportunities, but thinking through each one makes us, our naturally conservative lawyer selves step back and think through those issues. I hope that we've provided a list of those for you so that you can, as you're approaching your pro bono practice in Minnesota or around the country or around the world, how do you, kind of organize this? How do you think about it? How do you break down some of those key areas so that you don't let those concerns be a barrier to doing good in the legal profession? We have some time, I think just a couple minutes to take questions if there are any. And certainly, although we are in room 25, I will not be calling on anyone, so you can all feel comfortable. You did graduate, it's over. But if there are questions for the panel, we've got one up here and then we'll go. So, yes, sir?
I have a couple of clients from Iran. One is paying, the other one is not paying. My nightmare is, it didn't happen yet, but what if the government says, in order to prevent 9/11, if you will, in the name of national security and public safety, we demand certain information from your client. If there's such a demand, what should I do?
Right.
Have your ethics counsel on speed dial.
Have your ethics counsel on speed dial. I
mean, I think this is, I worry about this too, to be honest with you. I've had those same thoughts. I've had clients from all over. You have to safeguard your client information in a way that is, make sure that it's protected, that you're not emailing documents unencrypted or, have your server on an open network or so. I mean, obvious things like that. But if I got a demand from the government to turn over client information, the first thing I would do is call an attorney. Mm-hmm. And I would do a consultation with that attorney to find out what my legal obligations and rights are vis-a-vis that client. Mm-hmm. In no way would I simply turn over that information without understanding what my obligations are.
Right. And one of the things that we've really, we went through this as an immigration law office, open in after 9/11 or at the time, when the government was asking for documents from our colleague organizations who were not legal organizations. And we did sort of an audit of what we keep and what we ask. We don't have to ask certain things, so we don't. And thinking through what data are you collecting in the first place is always a good idea. So, yes.
Can you talk a little bit about the unauthorized practice of law and managing paralegals, specifically senior paralegals?
Great.
Oh, sure. This is another, gosh, immigration is so interesting. I would encourage everyone to go into the area. Oh, actually, I am going to speak into the mic now. So immigration in particular is an area of law that struggles with this issue. One of the ways that first of all, in private practice, I had a written policy, and all of my paralegals, regardless of senior status or junior status, were aware that they are not to answer any legal questions. And I didn't put them in the position also of having or feeling pressured to do that, because I think a lot of times what happens is that people don't necessarily start giving legal advice out of some, scheme to start their own side practice. I think some of it is just trying to be helpful, to be honest. So I actually would go through scenarios too with my paralegals and sort of to train them to understand what constitutes legal advice. I mean, I think we can tell people all day, don't give legal advice, but if someone doesn't know what that means, it's useless. So you have to make sure that the people that are working for you understand what that means, A. B, know what's happening. I mean, know what is happening with your own staff. And yes, that, I don't know if any of you, I'm very OCD, and I'm also, pretty on top of sort of what's happening with my employees, but you have to be involved in that. And your employees also have to know that they can come to you with questions. You're never too busy, and you're never telling your employees, figure it out on your own. That it's just bad practice.
Yes.
Brian, could you talk a little bit about conflicts? I'd be interested in hearing how you manage the conflict process in a firm environment where the issues are very, very different.
Sure. We're going to adjourn at 1 o'clock. Conflicts. The good news is, from a conflicts perspective, that the rule actually indicates that if you're working through one of these quick advice type clinics, you don't have to really know about any of the conflicts that are in your firm. You don't have to do a due diligence to find out if there's a conflict. It's if you have actual knowledge of a conflict at the time you're providing the advice, then you have an issue. But if you're meeting with someone, you don't have to say, I'll get back to you in 48 hours, let me run a conflict check with the firm. If you know of something at that moment, you do have a problem. What we do, and what everyone should do, obviously, if you have the time and it's not a minute conflict type of issue, you run a conflict check at the firm. You do what you would normally do. You identify who the prospective client is. You identify who the adverse party is. You give indications as to what the proposed representation will involve, what the subject matter is. And in our firm, in our process, there's both a computer check done by the client records department, who are staff members, and they will go through the computer database and look for anything that comes up based on parties or subject matter. And then an email goes out to every lawyer in the firm saying, is there an issue? Do you see an issue here? And so we go through, on a pro bono cases, unless again it's a minute advice clinic, we go through the exact same process as we would go through with any other client. And typically those don't get to be opened until there's a certain waiting period. And if there is someone, if the computer raises a flag, if one of the attorneys raises a flag, the attorney who's trying to open the file, the pro bono attorney, loses jurisdiction, if you will. And it goes to a group of people on a conflicts committee who are the only ones who can clear the conflict. It's the same with any of our clients. And they will do their own due diligence and make a determination as to whether or not this can be opened. In an IP perspective, it's conflicts on steroids. But when you're just doing, pro bono, it's not as complicated.
Yes, sir.
On the unique situation, I think people in a very unique environment, not likely to happen that often. travel ban. Can you address the what I might call the immigration lawyer community, people who do it not for pro bono but on a for a living? Okay, did you seek their involvement? Were they involved? Was there any resentment by those lawyers who make their living doing this by pro bono people? Those kinds of issues.
Great question.
Yeah, this is a fantastic question. So actually from the beginning, when the ban sort of was rolled out, we were working with the American Immigration Lawyers Association, which is the professional association of immigration lawyers. I'm a member, have been for years, and local attorneys. At least in the first 24 to 48 hours, I mean, it was really more of an emergency type response, trying to sort of get on the ground and figure out what even the legal landscape was. And if there were individuals that needed longer term assistance, or for example, if someone was contacting us from outside of the US, those cases were actually referred out to private counsel. And we were still on the ground at the airport, sort of serving as almost backup for attorneys that were already representing individuals that came through. So I'll give you an example. There's a local attorney that actually represented a family that was pretty highly publicized, actually, who had it was a woman and two small children, and the husband is actually a permanent resident here in the U.S. The wife and kids, I believe, were also permanent residents, but they were trying to come back into the U.S. when it was unclear whether permanent residents were actually going to be allowed in. That private attorney actually worked with us on the ground at MSP, just to basically get our assistance in helping to make sure that those individuals were able to come through. So he had a paying client, but at the same time, we were there to provide backup in the form of habeas filing and federal filing experience, should that be needed. So there was very close collaboration between the attorneys that were on the ground and the private bar.
I just wanted to add that I think the private immigration bar has been among the most generous members of the legal community in mentoring and supporting pro bono lawyers who do not work in that area of law. We have a lot of lawyers who are interested in doing immigration work and asylum work, but that's not their main practice. The Advocates has been very good about training and recruiting lawyers to do the work, but also lining them up with mentors who are quite active in working on their cases. So it seems to be a win-win relationship, I think.
We can take one more, sir, and then it's lunchtime.
Malpractice insurance, each individual attorney would be responsible for that. Do any of the organizations that cover this also insure those attorneys for malpractice insurance? And the second question, who pays the interpreter?
Right. So the question, first on malpractice insurance, most pro bono programs do provide malpractice insurance. Programs like the Volunteer Lawyers Network in Minnesota has a malpractice insurance plan. The Advocates for Human Rights has one that covers our volunteer attorneys who are actively engaged on our pro bono matters. They don't cover you for everything. But that does help eliminate a barrier to pro bono practice for people who are in government practices, who are in corporate counsel, who are solo practitioners, who are retired. Gives all of us an opportunity to participate. On interpreters, I think that varies from program to program. And one of the things that has been a new type of pro bono work is pro bono interpreters, people who are willing to volunteer their time because there can be really just an overwhelming need for languages. But often when we place a pro bono case on an immigration matter, the firm taking the case also will pay for interpreters like they would for any other client in there. That's part of the pro bono services. So it varies depending on the language, the availability, the capacity of everyone to do that. So you're going to stand between lunch. All right, one more.
I think there's one immigration problem that's you have to tell the client it's impossible, and that is
if somebody has renounced American citizenship and then changes his or her mind and wants to return, if that person probably couldn't find any really paying lawyer to take such a case, he comes to one of your pro bono people, what does that person say to this prospective client?
Well, I think, first of all, the question is actually incredibly fact-dependent, because if someone renounced and didn't have an understanding of what they were doing, or if there were other issues with the renunciation, I think that potentially there is an issue there. But what I would say, if someone came in with that question and the individual doing the intake didn't know, they should have a way to refer that question to a more experienced attorney who could take a look at that and potentially refer it out. Because funny enough, there are actually attorneys that specialize in those kinds of cases as well.
And that really brings, I think, a good closure to this, because there are matters that come into our doors every day at big firms, at solo practitioners' offices. I've got an issue. Can you help me? Sometimes we say yes, sometimes we say no because of our competence. As pro bono programs, it's our responsibility to do that vetting, to try to make sure that you know what you're getting. But all of us have that ethical responsibility to figure out whether there is an issue or isn't, and coordinate that and give the best legal advice we can, whether our clients are paying or whether they're not. It is really privileged to be in this space, working to provide access to justice to the people who can't afford it. We, as a profession, are really lucky to be part of that, and to be in a profession that respects that and fosters it. I want to thank the University of Minnesota Law School for putting this program together, Emily Jura for taking care of us and making sure that everything was ready to go. And I want to invite you all who have registered for lunch to make your way upstairs. Please keep your name tag on. I took mine off down here, but make sure you have your name tag if you're going to lunch. And then you can either make your way via shuttle out of the lobby or just across the bridge over to Weissman for lunch. If you're not, but are staying to participate in the other alumni weekend activities, I hope you have as much fun at your reunion as I did at my 20th last year. It really is a great time to connect with our colleagues. And thank you all, panelists, most especially, for joining us.